62. Alternatively, it was submitted that the defendant's conduct in publishing the videos on Facebook containing the material described above may lead to offences contrary to section 101.5, collecting or making documents likely to facilitate a terrorist act, or section 101.6, doing any act in preparation for planning a terrorist act under the code, particularly as the defendant is only required to be, open quote, reckless, close quote, as to the connection between his conduct and a terrorist act in order to establish those offences. I'm still not clear as to what offences. The direct accusation that he's going to hang someone or not. 63. The plaintiff argued that the connection between the videos of the kind made by the defendant and the commission of a terrorist act is a real one, given that those videos identify persons said by the defendant to be a legitimate target for retributive violence. Whether this is the judge's words, I think it's the police's words, retributive violence. Retribution for what, Matthew Reason? There's a key point there in that you've done something very wrong and you believe now that the violence would come back on the state in a retributive form rather than the initial form in that you're a fucking war criminal. 64. Whilst there are disavowals of violence in the material, these disavowals occur alongside statements such as, open quote, got to start carrying out action to deal swiftly with the foreign administrators ruling over our country with no rule of law, close quote, and open quote. I have now given you enough evidence to crucify this man, close quote, and open quote. No one is truly prepared for what's coming, close quote. No one is truly prepared for what's coming. And what has happened in the time since? Is everyone watching the world around them? 65. I interpolate here, in regard to these statements, that I do not see any of them as having sufficient clarity of proposed action to amount to a, open quote, call to arms, close quote, for violence. Interesting use of the word call to arms there, Justice Julia Lonergan, because what is a family coat of arms, everyone? It's a call to return. It's a call to come home. 66. Regarding the second risk scenario, the plaintiff submitted that the risk assessment report author has concluded that the defendant is, open quote, vulnerable to acting or engaging in violence to achieve the goals of the UKOA if the narrative was to shift towards the people of Australia adopting roles within the kingdom that is creating perceived legitimacy for engaging in violence, warfare policing, and or military jurisdiction, end quote. That's a very interesting statement to make that we shall look into a bit later. 67. The plaintiff submits that the risk is unacceptable given that the defendant had previously made threats to police officers that may reasonably be interpreted as death threats, that may reasonably be interpreted. That's a way of saying anything you say can be interpreted as a threat to me. 68. His previous non-compliance with the CCO, which occurred back in May 2020, was premised upon his ideological beliefs. This is cited as evidence of risk, as is his reluctance to engage in mental health treatment. His criminal history involves some violence and some past difficulty with anger management based on information provided by his de facto partner. These two are said to be matters that heighten risk. There's a lot of hearsay just in that 68 quote alone. The cited evidence, the words coming from people that are third parties, gathering all this hearsay together, is not actual fact. And that could be based on lies. 69. It was submitted that the court should place weight on the conclusion by the risk assessment report author that he is at, open quote, moderate to high risk of engaging in politically motivated violence, end quote. What we've noted from the report so far is that it is Matthew Reason that has the interest in the violence. He's the one that called the police of all states in defense of the war memorials. I wonder why that is, Mr. Reason. 70. He was not compliant with his CCO. There is a risk that he may not comply with his CTO. His beliefs and commitments amount to a type of, open quote, call to arms, close quote, to others with use of social media posts. He has some influence as a, open quote, leader, close quote, of the UKOA movement. Something doesn't make sense there, Mr. Reason. Something to do with God. 71. In broad terms, in relation to the relevant S25 factors, before incarceration, his behaviours were escalating, as was his level of fixation and obsession with, open quote, the cause, close quote. His delusional belief system regarding the legitimacy of the Australian government has real capacity for risk that he will either engage in activity or disseminate extremist ideology to radicalize and influence others. 73. I note that there is no evidence that the defendant was receiving any mental health treatment or support at the time of 2019 or 2020 offending. So that concludes the roundup of the plaintiff's argument noted by Justice Julia Lonergan. And what we can see is that there is a direct hatred towards what is now named and titled on Supreme Court record. And I will clearly say it is not the UKOA. It is the United Kingdom of Australia, as forged by your Anzac at the international treaties leading to imperial conferences, leading to a blessing of Almighty God. And it's that argument there that is not even brought up by this policy group.